Good morning, everyone. This is Shelley Jurowitz, Executive Director of FAB Wisconsin. I want to thank you all for joining us this morning, and how great is it to have the sunshine out today. I feel like we've been under clouds for the last 3 weeks, even though it's only been a few days. So thank you all for joining us and taking the time out of these crazy times to absorb some new information that we hope will help you as you're dealing with the various challenges that we're all facing during COVID. I want to take a moment to thank all of our members, in particular our premium members and our select members who go above and beyond for the organization that allow us to do sessions like this. So thank you very much to all of you. I wanted to point out that we have another great session coming up tomorrow. We've got some wonderful sessions lined up for June as well, and you can access all that information off the homepage of our website, as well as all of our COVID resources you can access off the homepage as well. So as you need, please take a look and dive in. And again, we try to schedule these sessions out in a manner that is helpful to all of you, as well as the content that we share throughout our web pages. I'd like to spend just a little bit of time to go through what to expect today. We actually will be recording this session, and we will make the PowerPoint presentation available to everyone. It will be posted to our past events archive page for your reference going forward, as are all of our sessions. We will offer some Q&A for folks, and I know that Gina has done a wonderful job of collecting some of those questions from our food and beverage companies in advance. But when we move to the Q&A portion of the event, there is a Q&A function found at the bottom of your screen, as well as a raise your hand function, and we ask that you please use those. We are thrilled to have Von Briesen, Reinhardt, and Foley with us today to share their expertise from the legal perspective, as I know that we've been getting a lot of questions towards that end. So without further ado, it is my pleasure to introduce Gina Balke, FAB Wisconsin's Director of Talent, who will be moderating the remainder of the session. Stay well, everyone.
Great. Thank you, Shelley. And thank you everyone for joining the call. I know it has been a crazy time and you are all extremely busy. So we really appreciate the fact that you were able to make time this morning to get on the call. I'm very excited about today's call. As Shelley alluded, we have been receiving a lot of questions in regards to legal questions around the CARES Act, the PPP, etc., unemployment. And I was actually telling Shelley and my husband that, you know, I almost feel like I'm a lawyer, even though I'm not a lawyer by any means, but just a lot of questions. And so when we were talking about next sessions, and as we were looking at some of our previous sessions and the questions that were being asked by our members, it was just, it was great that we were able to get 3 of our members to come on board to present to you today. So we are just thrilled to have everybody here today, and we're definitely looking forward to answering your questions as well. I do want to point out that, again, some of you have sent questions to us, which has been wonderful. As our presenters are going through their presentation, please feel free to ask questions by clicking the Q&A button below if you want to ask something. And you can also raise your hand on the right-hand side as well. So again, if you have any questions, please feel free to go ahead and go that way. So without further ado, we're going to move right into our session and go ahead and get our presentations up. I'd first like to introduce to you Ann Barry Hanneman from Von Briesen, and she is going to discuss with you today around employment law and the CARES Act. So Ann, take it away.
Thank you, Gina. I appreciate the opportunity to address this timely topic concerning the Families First Coronavirus Response Act amendments. I'd like to thank my colleague, Jeff Bartlett, at Von Briesen, who is our Managing Director of Finance for Von Briesen OneSource, for providing this opportunity to speak at this extremely timely presentation, particularly as businesses return to work during the pandemic, and we are fielding questions with regard to obligations under the Families First Coronavirus Response Act that I'll refer to as the FFCRA. In today's presentation, I want to cover with you what employers need to know to successfully comply with the FFCRA in order to protect their organizations from liability when providing the required leave mandated under this law, and to also provide practical tips to allow businesses to take full advantage of the tax credits that are afforded under this law. The goal here is so that you understand the legal obligations and can administer this law with confidence, and also to provide information regarding the documentation that needs to be retained to support the tax credits that are available. As Gina mentioned, we will be addressing throughout the program and my piece questions posed regarding specific scenarios where an individual cannot work because of a COVID-19 related issue that falls within the FFCRA. Next slide, please. When we look at the FFCRA, understanding the basic requirements is critical, since its signing into law on March 18 of this year. There have been 90 plus FAQs issued by the Department of Labor. The temporary regulations have also been issued, and the IRS has also issued related tax credits for paid sick and paid family leave that guides employers in understanding the documentation that's needed to obtain the tax credits available. These information pieces are a little cumbersome to navigate, and hopefully will provide some clarity through this portion of the program in providing those critical tips. As you know, the FFCRA requires employers with less than 500 employees to provide two types of paid leave. The first is the paid sick leave, referred to in the regulations as EPSL, and the Emergency Family and Medical Leave Expansion Act, which is technically an amendment to the FMLA. These requirements of paid leave are for qualifying employees for COVID-19 related reasons. Keep in mind that these provisions extend from April 1st of this year through the end of the year, December 31st of 2020. Next slide, please. When we're looking at what basic requirements need to be in place by all businesses that are covered, the first is posting the DOL notice or otherwise informing employees of their rights. This is particularly important because the employees should be informed. If you have employees who have been off and are returning to work, please remember to advise them of potential rights that they have under this law. When we look at what must be provided, the paid sick leave requires employers to provide qualifying employees up to 2 weeks or up to 80 hours for full-time employees at either 100% of pay or 2/3 pay, depending upon the reasons. As well, the expanded FMLA requires employers to provide 2/3 pay for those employees who have been employed at least 30 days with the employer, up to a total of 12 weeks. That's 2 under the paid sick leave and 10 under the expanded leave. With regard to these obligations, keep in mind that when imposing this law designed to allow for financial benefits to be afforded to employees and as well allowing employers to take advantage of tax credits, the thinking was that the requirement for notice be lenient, and that if an employer fails to give prior notice, that an employer work with that employee to provide the required documentation consistent with its obligations under the law. So we need to be careful as businesses before we deny the entitled leave to our employees. Next slide, please. When we look at the paid sick leave that must be required, one key piece is in determining whether an individual qualified for the leave is that the work must be available. And because of the reason, COVID-19 related reason, that individual is unable to work or telework. This is distinguished between an individual that simply does not want to come back to work for any non-COVID related reason. So when we look at the obligations under the paid sick leave, the first three listed here entitle an individual to receive 100% of the regular rate up to the cap of $511 per day, and that total of $5,110 per employee. When we look at the three reasons that entitle an individual for 100% of pay, the individual must be subject to federal, state, or local quarantine or isolation order related to COVID-19. Again, that isolation or quarantine order must prevent that individual from performing work that you have available to that individual. As well, number two is a healthcare provider requires that employee to self-quarantine, and because of that order by the healthcare provider, the individual is unable to work. The third reason is that the individual has COVID-19 symptoms and is seeking medical diagnosis. The key here with the third qualifying reason is that the individual is actually seeking a medical diagnosis requiring affirmative steps to be taken by that employee. This does not cover an individual who represents they have COVID symptoms, but is not seeking a medical diagnosis. The next slide, please. The other aspect of paid sick leave requires an employer to pay 2/3 of the regular rate for a full-time employee, scaled back for part-time employees, for reasons 4, 5, and 6 as listed on the screen, as well if the individual is unable to work or telework for the following reasons. The fourth reason as listed, caring for an individual who is subject to a quarantine or isolation order related to COVID. Again, it requires that self-quarantine, and that individual must have a personal relationship to the employee requesting the leave. The DOL regulations have defined this individual as an immediate family member, a person who regularly resides in the employee's home, or a similar person with whom the employee has a relationship that creates an expectation that the employee would care for that person if quarantined or subject to self-quarantine. Again, we can ask for that personal relationship. And again, the idea is that the individual employee is needed to care for that individual. Number 5 is caring for a child whose school or place of care is closed due to COVID-19 reason. The care must be needed and actually provided by the employee. When we look particularly at the definition of school, school is defined as an elementary or secondary school, and place of care is the physical location. Again, I mentioned the individual is actually needed for and is providing that care. If there is a co-parent or co-guardian, or a usual care provider that is available, the employee generally will not be eligible for the pay and leave under the FFCRA. Again, we'll talk in a moment about documentation, but an employer can have and should have the employee confirm that there is no other available individual to provide that care. The sixth reason is the employee is experiencing any other substantially similar condition specified by the Department of Health and Human Services, which to date has not been, additional information has not been provided. However, there is an expectation that there may be other qualifying conditions that would fall within this COVID-19 regulation. The amounts of paid sick leave here subject to a cap of $200 per day and a total of $2,000 per employee. Next slide, please. The other component, as I mentioned earlier, in addition to the paid sick leave that is required by employers, is to provide the expanded family and medical leave if an individual is unable to work or telework. For the fifth reason, where an individual is caring for a child whose school or place of care is closed due to a COVID-19 related reason. The cap here is $200 per day and a total of 12 weeks, again, adding the 2 weeks of paid sick leave, which is can be taken unpaid by the individual, or the individual employee who qualifies for that leave may opt to take that paid sick leave. Next slide, please. When we look at the tax credits, we must be mindful that the caps apply to the tax credits for which an employer can apply through the IRS, and the maximum capped amounts per employee are the limit. If an individual does qualify, and certainly the employer is qualified to provide those benefits, the IRS requires that an employer retain documentation for eligibility and the amounts paid. When we look at what documentation is required, the sources of those requirements come from the Department of Labor as well as the IRS. In looking at the entitlements, if an individual is required to qualify for the leave, for all leave, the Department of Labor requires retention of the employee's name, the dates of the requested leave, the qualifying reason and written support for that reason, and also an oral or written statement by the employee that they cannot work or telecommute or telework, because of the qualified reason. When we're looking at specific reasons, as I mentioned, in which an individual can qualify, the 6 reasons as stated, if an employee is taking leave for an order to quarantine or care for an individual subject to a quarantine, the individual must provide the name of the governmental entity issuing the quarantine or isolating order, as well, if caring for an individual, the name of the person and relation to employee. If the employee is self-quarantining or caring for an individual required by a healthcare provider, the employer should receive the name of the healthcare provider, as well as the name and relationship of the individual being cared for. For the fifth reason, that also applies for both the paid sick leave and the expanded family medical leave, required information includes the names and ages of any children that is receiving the care by the employee, as well as the name of the school or place of care that is closed due to COVID-related reasons, and a representation, as I mentioned earlier, that no other suitable individual is available to provide that needed care. And according to the IRS, if an individual is 15 years of age or older, if the child is 15 years or age or older, a statement that there are special circumstances that require that employee to provide care for that individual. When we look at the retention of these documents, it is a great practice tip to make sure that individuals who are requesting this leave have to complete a request form that requires this basic information. When we have drafted policies to communicate to individual employees, we've included these requirements so that individuals know when they request a leave or alert the employer that there is a need for the leave that falls within the requirements, that the individual will provide this information. Therefore, the employer then has all of the information necessary for the IRS, as well as the Department of Labor, certifying that the leave was taken pursuant to the FFCRA, and that employer is entitled to the tax credits for which they're applying. Caveat here is making sure, as financial obligations under other federal monies that have been distributed since the enactment of the FFCRA, that guidance has come down to assure that there is no double dipping on the use of provided federal funds. Therefore, if any employer is taking amounts under the employee retention credits, they carved out the amounts for the FFCRA, as we can't take tax credits for both funding sources. As well, or similarly, we need to assure that PPP funds also are not being used to pay these amounts, so that there is no, again, double dipping on the use of federally provided funds. Next slide, please. A couple of cautions as we move forward as individual employees come back to work. I can't underscore the importance of implementing carefully written policies to educate employees on FFCRA entitlements. We've seen some cases that have been filed alleging that employers are denying leave benefits and or return to work for individuals taking time under this law as required. So alerting and making sure individuals are aware of the leave and they understand the requirements. Employers who do provide notice, provide information about the requirements, are in a position to deny leave if indeed the employee, after written notice is provided, that the employee fails to provide the information that is being requested, again, under the DOL and the IRS regulations, as I've indicated. be careful with regard to documentation, as the DOL regulations are quite clear in saying that employers can't require more than what the regulations require and more than what the IRS requires. So we want to be careful that communications with employees are clear, we get the documentation we're entitled to, and we have the documents to retain for the 4 years as required under the DOL and the IRS for taking the associated tax credits. Couple reminders as we go through and employees are returning to work. Verify the head count at the time of requested leave. Again, this law applies to employers with less than 500 employees. That determination, if there's fluctuation, that may be a basis for denial of leave if at the time the leave is requested, the employer actually has more than 500 employees. Keep in mind too that rehired employees may be eligible if they are on the payroll for 30 or more of 60 calendar days prior to layoff or termination. And this will be particularly important to pay attention to as individuals return if they were laid off or furloughed. As well, there is no new entitlement if an individual employee has taken paid sick leave if that leave was fully exhausted, the 80 hours, when employed by a prior employer. So as we move forward, there are a couple of twists that we need to adhere to and pay attention to when we look at complying with the FFCRA. I do want to mention a couple of questions that were provided that in advance of the program relating to individuals who were taking leave for illness for themselves. As I mentioned, if that illness is taken due to COVID-related issues and that individual is seeking medical diagnosis, that individual, if otherwise qualified, would meet the tests for being eligible for FFCRA leave, and an individual must be provided with the opportunity to take the leave. As well, individuals who are taking leave due to a lack of work, due to a lack of childcare or school availability, if the closure is due to COVID-19, that individual would be entitled to FFCRA. Again, as individuals return to work and school remains out, the inquiry needs to be made when the individual returns, whether if, for example, the leave is for a summer camp that may be closed due to COVID, that would fall within the requirements. However, if when school lets out and the school year has completed, if the individual simply did not arrange for childcare for that individual would not be covered any longer or eligible to take family and medical leave. I look forward to your questions. Thank you.
Great. Thank you, Anne. That was very informative. And I know there are a lot of questions around the CARES Act and leave. So thank you very much. Okay, we are going to move right into our next presentation. And again, just a reminder, if you have any questions for Anne, please feel free to list on the Q&A at the bottom. Next, I'd like to introduce to you Christopher Schuley from Reinhardt, and he will be talking more about unemployment insurance benefits. For those of you that were on our call a few weeks ago with Secretary Frostman of Workforce Development, he answered a lot of questions about unemployment, but there were still some additional questions. So Christopher is definitely going to be providing you with some great information. So thank you.
Great. Thank you very much. Again, my name is Christopher Shealy. I'm an attorney at Reinhardt's Labor and Employment Law Practice. And today I'm here to talk with you about something that truly didn't occupy a very large percentage of my practice prior to March 2020, and that's unemployment insurance benefits. And I think that the reason for that really has a lot to do with scale. As we know, we've heard the term unprecedented used an unprecedented amount of times during the COVID-19 pandemic. But it really does bear repeating that these circumstances, especially with respect to unemployment, are really unheard of. Prior to March 2020, the weekly high for unemployment insurance claims made throughout the United States was 695,000 claims made in a single week during 1982. In mid-March of 2020, 3.2 million people filed for unemployment in a week. The following week, 7 million people applied, and now we have about 30 million claims that have been filed since March. It blows the past records out of the water, and as a result, the expansion to unemployment insurance programs in the various states, as provided by the CARES Act, has become critically important to employers understanding how best to manage their workforce through the pandemic. Next slide, please. So before I hop into the CARES Act, I just wanted to give a brief summary of what Wisconsin unemployment insurance law looked like prior to the COVID-19 pandemic. As I'm sure all of you know, unemployment insurance laws provide individuals with a source of income. It's a stopgap for those who are temporarily unemployed through no fault of their own. And the idea behind unemployment insurance is to simply get an employee from one employer to the next. Under Wisconsin law, unemployment insurance claimants are and were eligible for up to $370 per week for 26 weeks during a one-year period following filing a claim. That $370 per week was not owed to every single claimant. Whether you were eligible for the maximum of $370 depends on how much money you as the claimant earned during the 1 year period. It's really the 5-quarter period prior to you filing a claim, the first 4 quarters of that 5-quarter period. Common causes of disqualification include termination due to misconduct or voluntary termination. So if an employee resigned, they aren't eligible for unemployment benefits. Partial unemployment benefits were not available to claimants or are not available to claimants who worked 32 hours or more per week or earned more than $500 per week. And the exception to that rule was for those employees who were subject to a work share program. Now, partial unemployment, as you can imagine, would imply that someone hasn't lost their job, but their wages have been decreased considerably due to no fault of their own. The work share program under Wisconsin law is designed to encourage employers to avoid laying off employees, but rather reducing hours and allowing those employees to collect some form of prorated unemployment insurance benefits. Prior to the COVID-19 pandemic, if an employer was interested in applying for a work share program, it would have to cover at least 20 positions and it result in between a 10 and 50% reduction in working hours for covered positions. So not an insurmountable requirement, but nevertheless, the reduction or the work share program needed to cover at least 20 positions. And I've bolded a few terms in this particular slide just to keep in mind, because these requirements have changed quite a bit, at least in certain respects, as a result of something called the CARES Act, which all of us are very familiar with at this point. The CARES Act is that $2 trillion stimulus package that was passed by Congress and signed into law by the president on March 27th, 2020. Next slide, please. Now, again, a matter of scale, $2 trillion is a lot of money. And between this slide and the following slide, I'm just going to go through a little bit of the anatomy of the CARES Act. I don't think that we need to go into every detail by any means, but you'll note that the second item on the right-hand side of the chart states $260 billion in extra unemployment benefits. And that's what I am hoping to speak to a little bit here in these next few slides. How did the CARES Act impact the status quo under Wisconsin unemployment insurance laws and the unemployment insurance programs in the various other states? I know that Dan Kaplan will be presenting on the Paycheck Protection Program during our next presentation. And if you flip to the next slide, you'll see this is a continuation of the same chart. And you'll see in the small businesses row, there's $350 billion in new loans. That's for the Paycheck Protection Program that Dan will be speaking about shortly. Next slide, please. So how does the CARES Act expand unemployment insurance benefits under the various states' laws? Well, unemployment insurance is a sort of a hybrid federal and state program. There's federal funding and there's state funding, but in reality, the programs are each administered by the respective states. And as a result, individuals who are subject to unemployment insurance laws in one state may be eligible for more benefits than, say, if they worked or lived in a different state. But the CARES Act expanded all unemployment insurance programs across the 50 states, provided there was some agreement between the state and the federal government to accept these funds in three major ways. The first, which has become very, very popular in the news, is providing an additional $600 per week in unemployment insurance benefits through July 31st. Now let's remember, under Wisconsin law, the unemployment insurance claimants are eligible for a maximum of $370 per work week. This provides an additional $600 per week on top of that amount, making claimants eligible for up to close to $1,000 per week under Wisconsin law. In other states that have higher weekly benefits, we see individuals earning well over $1,000 per week in unemployment insurance. Now, some have commented that really this is quite a sea change in terms of what unemployment insurance is designed to do. Again, get an individual from one employer to the next. And I think that that's entirely correct. This is entirely different, and the goal is different. The CARES Act is really designed, I believe, to create wage replacement, to help individuals keep earning what they were earning, not less than what they were earning during an interim period. Now, this ends July 31st, so it's not forever, certainly. And in order to be eligible for this $600 per week in additional unemployment insurance benefits, an individual has to be receiving at least $1 of unemployment insurance benefits under their respective state law. So an individual cannot simply apply for unemployment insurance and hope to get just the $600. It's got to be $600 on top of some benefit that the individual is already eligible for. The second bucket of changes to unemployment insurance law pursuant to the CARES Act is providing an additional 13 weeks of benefits through December 31st. So as I mentioned in my first slide, claimants in Wisconsin are eligible for 26 weeks of unemployment insurance benefits traditionally. This is 13 weeks on top of that, bringing the total amount of weeks that an individual can collect through December 31st up to 39 weeks. Now, these first two buckets of expansions really are impacting individuals who are ordinarily eligible for unemployment insurance benefits, and that's employees. The third bucket applies both to employees, but primarily, at least popularly, to individuals who would not otherwise be eligible for unemployment insurance. Independent contractors, self-employed, think gig economy workers who have become ubiquitous in the economy in the last handful of years. And what the CARES Act provides is 39 weeks of unemployment insurance benefits through December 31st to mirror those that other individuals would be eligible for as employees to claimants who, as I mentioned, would be ineligible for unemployment insurance benefits, provided that the reason the individual is unable or unavailable to work is for a COVID-19 related reason. And there's a laundry list of reasons that are included in the CARES Act. Just to name a few, for example, the individual has been diagnosed with COVID-19, or a member of the individual's household has been diagnosed with COVID-19. Notably, the CARES Act also includes a category for individuals who are unable to reach their place of employment because they've been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Now, the independent contractors, the self-employed, are certainly eligible for this particular category of leave. The reasons for it are, of course, a bit narrow, and it may be subject to dispute whether those individuals are indeed eligible for that pay. But another group who's eligible are employees who have exhausted all of their unemployment insurance benefits. It may seem difficult to do, and perhaps it is, assuming that the employee has just become unemployed now. But think, for example, of an employee who has already exhausted or has worked towards exhausting their 26-week allotment during a 52-week period prior to the COVID-19 pandemic really kicking into high gear at the end of March. Those individuals may be eligible for unemployment insurance benefits through that third bucket of expansion. Next slide, please. Less than a month after the CARES Act was signed into law, we saw the Wisconsin legislature and governor sign our own coronavirus stimulus bill into law, and that's Act 185, which was signed into law on April 15th. It's truly a complement to the CARES Act in certain ways, and especially with respect to available unemployment insurance benefits. One key way that Act 185 changed Wisconsin unemployment insurance law is by temporarily suspending Wisconsin's 1-week waiting period for unemployment insurance benefits to kick in. Typically, under traditional Wisconsin law, an individual would have to wait 1 week before being eligible to receive unemployment insurance benefits. The CARES Act encouraged states to waive that requirement by stating that that first week would be fully federally funded. If the state were to remove that, Wisconsin chose to do so. And that waiver will go through February 7th of 2021. Act 185 also indicated that employer unemployment insurance accounts would not be charged for unemployment caused by the Evers administration's Safer at Home order. So there's a little bit of, I think, question that I would have as far as how those determinations will be made, surely on a case-by-case basis, but there's a provision in the Act for that. And additionally, Act 185 also eased work-share program requirements through December 31st, making it easier for employers to apply for and gain approval for a work-share program. Again, this is designed to encourage employers not to execute mass layoffs, but rather reduce hours across the board. Now, rather than covering at least 20 positions, work-share programs only need to cover 2 positions and can result in between a 10 and 60% reduction in working hours, rather than between a 10 and 50% reduction in hours. This is an application process that an employer must go through. My understanding is it's not particularly onerous. I've assisted a few of my clients execute the application with success. And by executing this program, and maybe I should have mentioned this earlier, an individual who is receiving a prorated amount of unemployment insurance benefits through a work-share program is also eligible for that $600 per week in expanded unemployment insurance benefits under the CARES Act. So it's a great way for employers to reduce their hours, limit the amount of unemployment that an individual would be eligible for under state law, but still allow those individuals to be eligible for that $600 per week, at least through the end of July. Next slide, please. So that's my very basic and brief summary of the various expansions to unemployment insurance benefits under Wisconsin law pursuant to the CARES Act and Wisconsin Act 185. I have found this particular area of my practice to be very rewarding, just given the questions I've received, because employers, it seems, during this time are very concerned about their employees landing on their feet no matter the circumstances. So I think that it's just very encouraging to see us all come together in that way. And I look forward to hearing some of your questions later in this presentation. Thank you.
Thank you, Chris. And yes, a lot of questions around the work share. So we appreciate your presentation and you brought some great information for our members. Thank you. Okay, and now we will move into our third presentation. And we have Dan Kaplan from Foley, who is going to talk to us about the PPP.
Thanks, Gina. I appreciate it. My name, as Gina mentioned, my name's Dan Kaplan. I'm a partner and co-chair of our labor employment practice firm at Foley and Lardner. And we have about 100 attorneys that are spending a lot of time dealing with the coronavirus issues just on the employment side nationwide. If you can go to the next slide. Here's the quarantine lawyer disclaimer. PPP is a moving target, as is a lot of the SBA loan programs. I think we receive at least updated FAQs or guidance or interim enforcement rules about every third day or so. And so because of that, what I'm going to be talking to you about is the latest version of the guidance, and that came out actually on May 17th. It's supplemented by the fact that we also received from the SBA the loan forgiveness application and its instructions for borrowers, which was released on Friday, late in the afternoon, early in the evening. And that document is a wealth of information, as it allowed us to better counsel clients on how you determine the number of FTEs, how you determine reductions in salaries, and things of that sort. Next slide, please. First off, everybody's concerned, or everybody wants to know about PPP. And as Christopher mentioned, PPP had a very large component, or made up a very large component of the CARES Act. It accounted for $349 billion of allocable funding from Treasury to small businesses being 500 employees or less. That funding was exhausted within about 3 days of the program opening. So Congress replenished the funding on April 27th to the tune of another $310 billion. So we have a grand total of close to $660 billion in eligible PPP funding. The subsequent replenishment, that extra 310 in late April, is still there. It has not been fully utilized. So if you are an employer or a company with 500 or fewer employees, and you've found yourself in more financial dire straits as a result of the coronavirus circumstances, you still can apply for a PPP loan. Some words of caution associated with PPP loan applications. There are certifications that you have to sign off on when you apply for the loan. So beware of those. And you should, as always, be honest when completing the application. The second word of caution is that both Treasury and Secretary Mnuchin, as well as the Department of Justice, have strongly suggested that they will audit any PPP loan that is in the amount of $2 million or greater. By the way, PPP loans cap out at $10 million. Whether or not Treasury, SBA, and Department of Justice is going to have the resources to audit all those that receive a $2 million or greater PPP loan is yet to be determined. Frankly, it would be a Herculean undertaking, and one that I doubt very much that will occur with the great majority of those loans. So the benefit of PPP is that it can be forgiven, or at least a large portion of it can be forgiven. So what that means is the PPP loan amount that the business receives can be converted into pretty much a grant from the United States government. It becomes quote unquote free money. Now, the free money has strings. The first string is that 75% of it needs to be utilized with payroll or for payroll costs. The other 25% can be utilized on other eligible costs. They're outlined here on this slide. Payroll costs include salary, wages, and things of that sort. The thing that we're not real clear on, because SBA guidance to date, as well as Treasury guidance to date, has not made this clear, is what about bonuses or what about hazard pay? The SBA loan forgiveness application does discuss payroll costs, including all gross salary and wages. So one might assume that bonuses and hazard pay are included, but it's not been specifically addressed yet under the regulations or the guidance from SBA. Next slide, please. As I started to describe, payroll costs include salary, wage, commission, or other similar compensation. This is the exact language from the Act and the exact language used in the regulations. So a bonus might not technically fall within salary, wages, or commission, or other similar compensation. Wages, you would think, yeah, bonus easily falls within wages. But when salary and wage are used in the same sentence, it's been commonly determined or referred to as hourly wages. So folks who are not receiving a salary are receiving hourly wages. Again, bonus not quite in there. I think if you look at the intent of the PPP program and the CARES Act, it's to A, ensure that employees are not on the UI rolls that Christopher described and receiving that extra $600, but rather are receiving pay for performing that essential work or all work that this country needs to continue operating. If a company requires a bonus or some sort of hazard pay to incent its employees to show up to work, one would arguably think that that is consistent with the intent of the program. Again, we don't really know yet. I think it is consistent with the intent of the program. Other components of payroll costs include cash tips, payments for vacation, payments for other leaves, separation or severance pay. Careful here. Severance pay is probably going to be a little bit different, right, than a severance pay provided in order to get a release from an employee. So just bear that in mind. One large exclusion or caveat with respect to payroll costs is you are not entitled to include costs above the cash compensated awarded to any employee that exceeds $100,000. So if you have a $150,000 manager, you can include up to $100,000 of that cash compensation, but you may not include for forgiveness that extra $50,000. Next slide, please. Again, in order to be forgivable, there are a couple of thresholds, and if you don't meet those thresholds, the amount of forgiveness is reduced. The first threshold is that 75% of the forgiveness amount must be allocated to those payroll costs that we talked about. The other 25% can be used for mortgage payments, insurance, and other similar type benefits, utility costs, things of that sort that are included by or incurred by an employer throughout this pandemic period. The other two potential reductions to the forgivable amount deal with a wage salary reduction or an FTE full-time equivalent employee reduction. And I'm going to talk about all three of these on the next slide. The 75-25 split. So let's assume for a moment that you received a $4 million PPP loan. Your payroll costs during the covered period, by the way, and we'll talk about this in a moment, the covered period is the 8-week period that follows the initial disbursement of your PPP loan. The more recent guidance, as well as the loan forgiveness application that came out at the end of last week, suggested that borrowers may utilize what's called an alternative covered period. That alternative covered period allows you to start your 8-week timer at the first payroll that occurs after disbursement of those funds. So back to our example, $4 million PPP loan, payroll costs during the 8-week period is $2.5 million. Your other eligible expenses, whether it be rent, mortgage payments, utilities, things of that nature, equate to about $1 million. The total that you have expended during that 8-week period for which forgiveness is at least arguably available is $3.5 million. First off, the extra $500,000, you don't have to give that back. That becomes a loan consistent with the terms of the SBA program, which means it's going to accrue interest at the rate of 1%. And you have a 6-month deferral of any payments and interest on that outstanding amount. It's a great loan. No other businesses have access to that kind of funding. So let's talk about, can we get the full $3.5 million forgiven? The answer is no. The reason the answer is no is because if you look at the amounts that were spent on payroll costs versus the amounts spent on eligible expenses, the borrower didn't meet the 75-25% split requirement. How do you determine whether or not it's been met or what amount can be forgiven? The simple approach is to take your payroll costs, multiply it by 0.75 or divide it by 0.75, sorry, and you'll come up with the total forgivable amount of your PPP loan. In this case, $3.33 million. So that means that, yes, we can still get forgiven or have forgiven our $2.5 million payroll costs, but we are only allowed $833,333 of the other eligible expenses. When the SBA and Treasury calculates what amount will be forgiven, they will look at 3 forgivable calculations, and they will allow the lowest dollar value. The 3 forgivable essential calculations are listed on this slide. First, could be the entire amount of the PPP loan if you've met all of the threshold requirements. Second, it may only be the PPP loan amount after reduced by the 75-25 split, similar to the 3.3 that we just discussed. Or third, it may be all of the eligible payroll costs and eligible non-payroll costs reduced by the salary, wage, and FTE employee reductions. Next slide, please. So how do the salary, wage, and FTE reductions work? Remember, part of the intent of the CARES Act and the PPP was to ensure that employers keep their employees employed at or about the same rates that they were being employed prior to the time period when the pandemic really hit full bloom, essentially March 1. So on this slide, and again, all of these slides are downloadable, and I'll recommend downloading these because it gives you a pretty easy calculus. If hourly wages are reduced by hourly or salary wages, sorry, are reduced by greater than 25%, as compared to the pre-covered period, essentially, then you have to take a reduction that's similar to that from the forgiveness calculation. So you can reduce employee comp by up to 25%. Anything over 25% will be a hit on what amount is forgivable. Next slide, please. On the headcount reduction, it's a similar sort of reduction. What the SBA wants employers and borrowers to look at is, what was our headcount during one of two periods? And the one of two periods is either from February 15 of 19 through June 30 of 19, or the average number of FTEs from the period January 1 through the end of February of 2020. And you want to pick whichever's less, right? So you use whatever is the average number of FTE from either of those two periods, and that number is your denominator, and then your numerator is the number of FTEs that you employed on average during the covered period. Again, that 8-week period. Where the calculation is less than 1.0 of numerator over denominator, whatever that calculation is then applied to your forgivable loan amount, and it reduces it accordingly. Again, calculation is fairly well laid out in the loan forgiveness application. And there is a worksheet and a schedule that borrowers can complete to assist them with filling out that loan forgiveness application. The schedule itself has to be submitted with the application. The worksheet is there for your use and guidance. One little benefit or caveat that existed is, if you had employees that you furloughed or laid off anytime between February 15 and close to the end of April, you don't have to reduce your FTE count for purposes of calculating your numerator, so long as you bring back to employment by June 30th that same number or up to that same number of employees. So for example, if you laid off 5 employees between February 15 and the end of April, and your FTE calculation for the covered period was 5 FTEs below what the average was for the pre-coronavirus period, so long as you rehire or bring those 5 employees back by June 30th, you get to add 5 more FTEs to your numerator, which brings you back to 1.0. There's no guidance on what happens if you bring them back and then terminate them after June 30th. But beware, obviously, anybody who receives a loan of greater than $2 million, that's going to be one of the audited functions of the PPP program. Next slide, please. Foley has a Corona Resource Center, as does Reinhardt and the other attorneys who have been presenting throughout this process. And every law firm pretty much in the country has one. There are some good materials at the CRC or the Corona Resource Center for Foley and the other law firms that you may utilize. Most of these resources are searchable by either topic or keyword, as is our website. I'd encourage a lot of you to just go check them out. A lot of good material there. Some of the problem associated with all of the material is there's just so much of it that it becomes difficult to kind of synthesize down and decide what is it we want to use. And I would encourage you to reach out to your employment counsel and use your employment counsel to bounce that off of them. That's all I got. Thanks for your time.
Great. Thank you, Dan. Thank you. Those were great presentations. We are going to move into the Q&A portion. I know we are running a little past time, so for those of you that do need to get off the call, we completely understand. I do have a few questions, and I am going to also ask if any of you on the call would like to ask a question versus typing it. I know some of this can get a little long. Please feel free to raise your hand, and then I can call on you as well. Okay, so question one. Most of our food and beverage manufacturers have adopted the best practice of temperature taking of their employees. And there's been a lot of questions around, who is the best person to be taking temperatures and so forth. We've heard everything from someone in HR taking it to quality people taking it and so forth. Questions have come up though as to what is the best practice in regards to temperature checks to prevent HIPAA violations. And is there any risk of a HIPAA violation if we are disclosing that a potential employee has COVID-19? Not sure who would like to take that first, but I guess get your opinions on that.
This is Ann. I can address that. Generally speaking, taking temperatures during the pandemic as authorized or at least acknowledged by the EEOC is okay practice as long as confidentiality is maintained. HIPAA is a law that is for healthcare providers and insurance plans. So an employer would not be involved or likely to violate HIPAA, but the employer is not under EEOC regulations permitted to disclose the individual who tested positive, but is able to inform public health officials of the COVID-infected employee.
Great.
And this is Dan. I'd like to just offer one other piece of quick advice on this too. We have counseled our clients, and I think most of your employees will agree. Just as Ann pointed out, you don't violate EEOC or the ADA by taking temperatures, at least not during a pandemic. You may end up violating it if you disclose an individual's results without their permission. Most employees, if you share with them and ask them if it's okay for you to share the fact that you have a temperature and are required, or the employee is being required to self-isolate, and that the reason you want to share that information is so that your coworkers are safer and their families would be safer, will readily agree to that disclosure. And so it's my recommendation that you ask if the employee will agree to that. And if they will agree to it, you confirm it in a written email to the employee. But being able to contact track this kind of close contact with employees is extremely important for gaining control of the virus spread.
Great, thank you. I am gonna give an official call off for those of you that do need to get off. But again, for those that want to stay on for an additional 10 to 15 minutes, we do have some additional questions, and feel free to ask questions as well. Okay, Dan, I'm gonna ask you this one first, and then Ann, if you want to jump in after. But Dan, for employees on extended FML, where are they accounted for on the PPP forgiveness application? Can we count them for future employees, but their salary doesn't count because it was credited with payroll taxes?
That's exactly right. So for purposes of an employee who may be on a leave of absence, they are still regularly scheduled or normally regularly scheduled to work 40 hours a week. So they would be an FTE from the standpoint of, if you're not paying them, right, then you are not able to utilize that as part of the forgivable calculation. And if you take the FFCRA credit, you do not get to double dip. So if they're out on an FMLA and receiving the amounts that Ann described for purposes of FFCRA benefits, the 200, up to a maximum of $200 a week in extended FMLA benefits. You don't get to include that amount, but any amount that you pay over that, you would get to add into your forgivable calculation.
And I would just like to add on that score, where we have had clients in this situation, the client has made the decision not to take tax credits under FFCRA and to use the PPP funds. But again, you want to make sure that there is no tax credit that is applied for that individual on the extended FMLA. So therefore you have and can show that there wasn't the application for those tax credits, so that there is no double dipping. Most of our clients have prioritized the PPP forgiveness over taking the tax credits under FFCRA, and where the individual has been fully paid using PPP funds.
Great, thank you. Question, this will be for Dan and for Chris. I have a PPP loan and will be bringing back employees furloughed part-time. How does PPP and unemployment work together?
From the PPP standpoint, the forgiveness application points out that you have two means to calculate FTE. You can do it based on the actual 40-hour work week and what percent they're working or back to work, whether or not they're a part-time employee or otherwise. From the, or you can do it as they're either a 1.0 or a 0.5, right? If the employee's back, right, only as a part-time employee, then that's the allocation you'll give in as far as an FTE goes. As far as the amount of benefits that they otherwise can receive, I'll let Chris respond to that from a UI standpoint.
Yeah, and I think, unfortunately, it's very difficult for me to give any sort of very concrete guidance on that question, because the amount of unemployment benefits that an individual is eligible for depends explicitly on how much that individual was making during the 5-quarter period prior to applying for unemployment. What I would recommend is that, I guess, those individuals are certainly welcome to file for partial unemployment, and it may even be beneficial for the employer under these circumstances to apply for a work share program, and to, in their application, state something to the effect of, we are looking to bring people back. We can't do it at our full capacity as a result. Rather than limiting the amount of people that we're bringing back, we'd like to spread any sort of decline in work hours across the board. And maybe that would be an appropriate, I guess, way to utilize that program.
Great, thank you. Where do you see employers' biggest risk in regards to employment law during COVID-19 times?
This is Dan. I guess I think your biggest risk from an employment law perspective is not necessarily from an employee contracting COVID-19 in the workplace, because I think you have work comp coverage, especially in Wisconsin. What I think your biggest risk is the failure to follow the guidance that employers are provided with, either by the CDC or others, on how to best protect employees from contracting COVID-19 or customers. And if one of those employees or customers takes COVID-19 back to somebody who is not an employee, and that individual suffers a catastrophic occurrence or death, and then you're facing lawsuits based on that. So I think the number one rule for employers who are either open now or will be opening soon is that you adhere to those best practices and those guidances about how to open up safely, right? The disinfectant, the face masks, the constant wiping down of regularly contacted surfaces. I think that's your biggest exposure.
Dan,
Well, Chris. Yep, go ahead, Chris.
Yeah, thank you. Dan, I think that's a great point. The only thing I would add, and it's not something that we've discussed specifically here in this presentation, but typically in my line of work, I find that the bread and butter for plaintiffs' counsel bringing claims against an employer, at least for my practice, has been class and collective action lawsuits for wage and hour claims. What I view as potentially the next wave of that very plaintiff-friendly sort of claim could be under something like the Federal WARN Act or the state law equivalent. And the WARN Act, or the Wisconsin WARN Act, a mini WARN Act enacted by a particular state's legislature, requires certain notice obligations when an employer is terminating a certain amount of individuals pursuant to a mass layoff or is shutting a plant down. There are, of course, certain exceptions that arguably would apply to these circumstances, being those where notice reasonably could not have been provided under the circumstances, given how quickly all of the coronavirus pandemic really bubbled up in our society and economy. However, I do think that that could be a claim that could be brought on behalf of a class very easily, and potentially could be something we see more of, maybe not tomorrow, but within a year, 2 years of everything subsiding.
Great, thank you. And Anne, what are your thoughts?
I think this is a terrific question. I believe that, along with Dan, the employee health and safety challenges that an employer has really is immense and ever-changing. And I think putting those policies and practices in place is key to protecting individuals and stopping the spread in the workplace. The companion to that is communicating those policies and assuring that those practices are followed. There is a trend that we're seeing with employees coming back to work and not adhering to the guidelines and policies that are put in place. We really, as business owners and employers, we really need to be diligent about making sure during the length of this pandemic that we are monitoring the practices and assuring from a health and safety standpoint that we are doing all we can to protect our employees, consistent with our legal obligations, consistent with the guidelines, as well as any customers or visitors that come onto the premises, because I think there is certainly, until liability is protected in that regard, I think there is great risk to employers in that space, and monitoring and adhering and enforcing those policies and regulations is really one of the biggest challenges that we face.
Thank you. I think we'll take 2 more questions. So if you do have a question, please feel free to raise your hand. I will ask a question about, do you see emergency paid FML becoming the norm after COVID-19?
This is Anne. I don't think so. Certainly, depending upon the length of the pandemic, you know, it is set to expire certainly at the end of this year. And I don't believe that this type of emergency type leave will be extended.
Okay, this is a little hypothetical, but although the HEROES Act has not passed yet in the Senate, just curious your thoughts on what might change in regards to some of the CARES Act.
Yowza, that's a tough one. This is Dan, and well, we know the HEROES Act's not going to pass. It will, something will come out of this proposed legislation. It's not going to be what's come out of the House. There's going to be bargaining. There's going to be a lot of back and forth. There's going to be more money. I think what's going to end up happening from the standpoint of the impact to the CARES Act is I can very easily see the states receiving a lot more funding, as well as the healthcare systems receiving a lot more funding. And I think individuals are going to see some benefit. So I think right now the PPP program has not been fully utilized, right? The secondary or the supplemental funding has not been used up. So there's not a huge incentive to expand that program. But we still have an unemployment rate of close to 15%, which is unimaginable. And we have these $600 benefits that kick off after 13 weeks, as Chris was talking about. So I think you're going to see a lot in the area that Christopher was speaking about. I think you're going to see expansion of UI benefits. I think you're going to see some opportunities to slowly get those persons back to work and some financial support for them while that's occurring.
Yeah, this is Christopher. I tend to agree. I think that the direction that Congress is likely to go is towards the individual and perhaps even to specific industries. I know that certain industries, like for example, the airline industry, was specifically targeted by the CARES Act and was, provided with certain funds that were earmarked specifically for it. But I'm curious to see what other industries are going to desperately need funding and whether Congress will have the appetite to address those specific needs, 6 months, a year from now. I think a lot of the issues that we're, talking about right now or, hypothesizing, I don't know that we know where the pandemic is going to turn our economy or change our economy, at least to the extent that I think it could in the future. So I think much of it remains to be seen, but targeted efforts, I think, is a good bet.
Anne, would you like to give your thoughts?
I would echo the sentiments. I do think that there is attention being paid to industry-specific needs with regard to specific relief that will be afforded. And I think generally speaking, the focus will be to correct, if you will, the amounts of money that have been designated in terms of what's working, what needs to be modified, and how the funds may be best used, particularly in specific industries that have been hit hard. Airlines, restaurants, etc.
Well, great. Well, thank you all very much. We have come to the end of our call. I appreciate those of you that stayed on for additional questions. And if you do have any other questions, please feel free to email me. Again, thank you to our presenters. You all did an amazing job today, brought some great information for our members. And we will have this recorded, so we will make it available for our members. And again, thank you again. Everybody stay safe and have a good rest of your day. Thank you.
Thank you very much.
Thank you.
Bye.